I absolutely love the A102-2017 agreement between owner and contractor, where the contractor gets reimbursed for the cost of their work up to a GMP, as a wonderful form of contract to use, regardless of whether I'm representing a general contractor or an owner on the project. The AIA document A102-2017 is the standard form of agreement between the owner and the contractor, where the basis of compensation to you, the contractor, is the cost of the work. That's capital C, capital W, cost of the work. It's a defined term that is code for the sorts of costs that the owner is going to reimburse you for, plus your fee, which is typically a percent-based fee. So the more cost of work you're reimbursed, theoretically, the more fee you recover, with a guaranteed maximum price, which we sometimes call a GMP or a GMAX. So sometimes people will call it a cost plus GMP agreement. Sometimes people will call it, the A201 owner contractor agreement subject to a GMP. The bottom line is that this is different than the kind of owner contractor agreement where the owner is going to pay you a fixed contract sum. The fixed contract sum form of agreement, the flagship AIA fixed contract sum agreement between owner and contractor, that's the A101-2017. I've got other videos about that. This one that we're tackling today is the A102-2017. And again, it is the agreement that you as the general contractor will reach for if the owner isn't paying you a fixed contract sum, but instead is going to pay you your actual cost of work as you accumulate it over the project, capped at a GMP. Now, of course, the GMP is subject to change by change order, just the same way that a fixed contract sum is. But the idea is that rather than have, a fixed contract price where you get paid a percent of that contract price based on how much work you accomplish in a month, here it's you're going to get the actual cost of your work as it accumulates up plus your fee, capped by the guaranteed maximum price. Of course, this is the kind of contract that an owner and a contractor would reach for in the traditional tripartite contracting situation, where the owner has a separate contract over here with the architect, and then they have a contract with you, the general contractor, over here. This is not good for a design build project where the owner is only going to hire one entity. But if it have that three-party situation where the owner hires the architect over here and the owner hires the contractor over here, and this is the A102 contract that we're talking about right now, that three-part relationship, there is another document that sort of sits in the middle of the three parties. It's the A201-2017 General Conditions document. I can't tell you how important it is for general contractors to understand that that document is incorporated by reference, meaning you don't have to sign it, you don't have to see it. It is going to be part of your contract with the owner almost all of the time if you are using AIA contract documents, and if the owner is going to separately hire the architect over here with a contract and separately hire you, the general contractor, with a contract over here. That A201 General Conditions document is incredibly important. It's 38 pages long. It says the word contractor more than 500 times in it. So if you're a general contractor and you're hearing this, you should take away not just everything else I'm going to cover in this video about why I think the A201-2017 is a great contract form. We're going to talk specifically about its 16 individual articles and the way that I'm going to suggest that contractors think about putting custom modifications in. Those things are important, but if you're the contractor, don't forget that it's not just the A102-2017 that forms a part of your contract with the owner. You also have to be cognizant of the A201-2017 General Conditions document. It's got the word contractor in it more than 500 times. It's got the word owner in it more than 400 times. And it's got some variety of the word architect in it more than 300 times. So you have to know what it says about what you're going to do. You as the general contractor make a lot of promises to the architect and the owner in the General Conditions document. And again, even if you never see it, even if it's never negotiated, it does not call for a signature. It is automatically incorporated by reference into your contract. unless there is something in your contract that knocks it out, which is something that I wouldn't recommend you do. There's some really essential terms in the A201 General Conditions document. Article 8 talks about time. It's got a force majeure clause. It talks about when you'd get an extension of time. Article 9 of the General Conditions document talks about payment. There's some critical terms in there that a contractor is going to want to be cognizant of. Article 10 talks about the extent to which you're responsible for safety. Article 11 of the A201 General Conditions document has some really critical insurance terms that are going to play off not just the A102-2017 owner-contractor agreement, but also its insurance exhibit. So it's not a great idea for you to knock that General Conditions document out of the box and to say it doesn't apply. And it's an equally bad idea for you to reach for an A102 or an A101 or any other AIA owner contractor agreement on a project where the owner is going to hire the architect in one contract over here and hire the contractor separately over here. Anytime that you have that arrangement, you're going to want to know that the A201 is out there, and you're going to want to make sure that you pay very close attention to the promises that you're making to the architect and the owner, but largely the owner in that contract document. As I mentioned, the key differentiator between the A101-2017 contract, which is a fixed contract sum agreement, and the A201-2017 owner contractor GMP agreement, which is what we're going to cover now, is that the latter, the GMP agreement, assumes that each month you're going to incur costs, you're going to invoice the owner for the same, you're going to throw your percent-based fee on, and you're going to try to make sure that you don't exceed the guaranteed maximum price as it may be adjusted by change order. You know, the major disadvantage to using the A102-2017 in my view, and I preface this by saying that I love the A102. I use it all the time. I doubt that there will ever be a time for the rest of my career where I will not be negotiating at least one A102-2017 owner-contractor agreement, because it's very good and I use it all the time. Its principal downside that I will say, after telling you how much I like it, is that it's a more complicated method of the owner paying you, the contractor, than simply giving the owner a fixed contract sum and billing a percent complete basis. I'm going to get into some of the reasons why that's the case, but the A201 cost reimbursement contract is about 10 pages longer of standard text, because there's a lot of nuance around like the word cost, the phrase cost of work with a capital C, a capital W. That is code for the kinds of dollars that you are going to be reimbursed for. Those costs are addressed in great detail in Article 7 of the A102-2017. That entire section talks about the kind of cost of work that you're going to be reimbursed for. And you have to juxtapose that against Article 8 of the A102-2017, which is going to talk about what falls outside the category of capital C, capital W, cost of work, what kinds of costs are not the kind that the owner is going to reimburse you for. And just having those two additional articles, Article 7 and Article 8, to draw the line between what you're going to be reimbursed for and what you're not, that by itself adds a page and a half to the A102-2017 that isn't present in the A101-2017, because again, the A101 fixed contract sum, it's a much simpler way of running the project. You just bill on a percent complete basis. Now, with that said, there's a lot of good reasons to prefer the A102-2017 to the A101-2017. In other words, there's a lot of reasons why a well-advised property owner might want to use a cost reimbursement method to pay you. And there's a lot of reasons why you as a general contractor might prefer to be reimbursed your actual costs up to a GMP. And so I don't mean to scare you off and to suggest that you should not use the A102. I think that my main message for my property owner clients and my contractor clients is you want to make sure that you're picking the contract form that is best tailored to help you achieve your ends. And it could be an A101, it could be an A102 or an A103 or an A104 or an A105 or any number of the other contract documents, but you're going to want to pick the one that's best for you. What are two principal advantages of using an A102 cost reimbursement up to a GMP method of being reimbursed by the owner? Well, one is the possibility of achieving shared savings, right? So if we say that your cost of work every month is going to bill up to a certain level, then you complete the project. If that dollar amount, call it $1 million, is under the GMP, call it 1.1 million, we've got $100,000 of shared savings. And as I'm sure you know, it's often the case that a well-advised owner is going to want to share those savings with you, the general contractor, because they want to align their financial incentives with you. They benefit when you don't spend their money, and you can benefit when you don't spend their money if there are shared savings involved, right? So let's think about this for a second here. If, let's say, that you've got a 5% profit margin, let's say that your fee is 5%. If you spend $1, you get a nickel. Okay, but if you are sharing savings under the GMP with the owner, if you save $1, you get 2 quarters, right? And think about that. 2 quarters is a heck of a lot more than a nickel. So if the owner is going to share savings with you, if you're able to achieve those savings, you have the ability to put a bunch of quarters in your pocket, and because you're not spending that money, you're not buying materials, you're not installing materials, it goes right to your bottom line. It's like rocket fuel for your profit. So one of the major advantages for you, the general contractor, to using a cost reimbursement method of being paid with a GMP is if you can work really hard to figure out value engineering, if you can go to the architect and go to the owner and say, hey, I actually have a cheaper way we could put the wall together, and it's going to be code compliant, and it's going to satisfy the architect. You could come up with all these ideas. You could have a lower cost of work, and then you can share those savings with the owner, which is an excellent thing for all general contractors if they can get it. And it also allows you, to get a shovel in the ground to fast track a project where the architectural and engineering drawings are not sufficiently complete for you, the general contractor, to give the owner that fixed contract sum for the whole project that may not be achievable. If you have an owner that comes to you and says, we got to go, I want to start site work, I want to dig the foundation, we got to get structure going, we've got an early procurement package, we got an early site work package, let's go. You as the contractor, can say, okay, well, I can't give you a fixed contract sum for the whole job right now because the architectural and engineering CDs are not going to be done for 9 months. But, using a cost reimbursement method of being compensated under the A102-2017 is one of the ways that the owner can hire you in order to, secure the project and get going, even though we don't have complete contract documents, or I should say issue for construction documents from the owner's design team. Now, of course, if you're going to give the owner any kind of a GMP, those architectural and engineering drawings have to be developed to a certain extent, or you can't give a GMP, right? I mean, if you only have, like a civil site work foundations package, you're not going to be able to give them a GMP for the whole project. And in those cases, it's possible for you to come to a construction lawyer like me and say, Jeremy, can you customize the A102 so that we can fast track this project and we can begin to do that early work, and then we will later decide what the GMP is going to be for the rest of the project? Absolutely, I do that all the time. I could add a page or so of language, of custom language to the A102. It says that, this is the cost for what the contractor is going to do, on a fast track basis out of the gate. And then at a point in the future when the contractor has the construction documents in hand, they can propose a guaranteed maximum price, and I can lay out rules of the road for how long the owner has to consider your proposal before you get to go back and rebid it to your subs. And, I can set up the rules of the road for there being a GMP later, right? So we could do a whole bunch of stuff. And to be honest with you, it doesn't have to be an A102. We could do all these things with an A101, as well. But the key point is that we can help you fast track the project without getting stuck with either a GMP or a fixed contract sum that you can't deal with. We could do a limited notice to proceed with certain work only. We could have a fixed contract sum or a GMP for the part of the design that's completed, and we could have allowances, for the rest. Or, as I mentioned, we could set out language in the agreement that would say this is phase one, phase two, is going to be subject to a GMP proposal that the contractor is going to provide later. So there's a whole bunch of stuff that we could do to a wide variety of contracts in order to make them flexible for you to get a shovel in the ground quickly. We can certainly do it for the A102-2017. It's one of the main reasons for using a form of agreement other than a fixed contract sum agreement is if you need to fast track the project and get a shovel in the ground quickly. But I think that one of the principal reasons why a contractor may be interested in using a cost reimbursement method of project reimbursement rather than a fixed contract sum is those shared savings can be so powerful. I mean, if you can get an owner that's willing to split savings with you under the GMP, and you can put 50 cents in your pocket for every dollar you save the owner, that is going to be, 6, 7, 8, 9, 10x, what would be a typical percent-based fee on the project. And because you're not buying anything or installing anything, it goes straight to the bottom line. It's not like top line revenue. It's rocket fuel for profitability. So there's a lot of reasons why a contractor is really going to want to think about a cost reimbursement method of project payment rather than a fixed contract sum. As I've talked about in my general video about the A102-2017, which I shot, earlier this morning. I've gone into some detail there generally about why any off-the-shelf agreement that you're going to purchase from, a group like the AIA or the Consensus Docs or the EJCDC or whomever you're buying your standard form of agreement from, it's just a starting point for negotiations, right? There's no such thing as taking one of these forms off the shelf, just filling in the blanks, signing it, and having a great agreement. You're going to, as a well-advised general contractor, you're going to want to think about what is it that you want to add to the A102-2017 by way of custom contract terms in order to better protect yourself. Some of these things are going to be client specific or project specific. You may have an owner that wants you to be paid through an escrow agreement. You may want an owner that, is going to have high expectations for retainage, and you may want to vary some of those terms. You may have an owner that wants to issue joint checks to you and your subcontractors for, payment. There's a million and one things. You might have an owner that is going to want you to work around the clock, 7 days a week, because speed of delivery is very important to them. And so, I need to see those things. I need to know, is it a rehab job? I need to know, are you digging near a property line? I need to know whether or not, the owner is going to be funding you in part through state or federal monies that might trigger an obligation for you to pay prevailing wages. There's a whole wide variety of custom issues that are project specific and client specific that me as a construction lawyer, when I'm representing you as a contractor, I need to do what I call this issue spotting exercise, and I'm going to customize up the A102-2017 owner contractor agreement to make sure that you're protected as a contractor. And the truth is it really doesn't matter what form of agreement we use, whether it's an AIA agreement or not, whether it's some other industry group standard form of agreement, whether it's an agreement that is pushed across the table at you by your client, the project owner. I'm always going to want to go through an issue spotting exercise to figure out what are the project and client specific eccentricities of this job that are going to need specific contract language so that we don't have surprises, right? I mean, the whole point of a contract is to not have gray areas so we don't have disputes that arise where you get into a staring contest with the owner and you wind up in a bad situation where you don't get paid. You want to have all of the things that are likely to arise on the project addressed with, reasonably fulsome contract language so that when you hit the speed bumps on the project, you can pull the contract out, you can look at it, and there's a resolution there. In addition to the edits that I would put in to protect a well-advised general contractor in the A102 around issue spotting, the project and client-specific stuff, there's a wide variety of customization that's necessary just based on, what state you're in. There are state laws that govern payment. If you submit a payment application to an owner, how long do they have to review it before it's deemed automatically approved? Same thing with you. How long do you get to look at a subcontractor's pay app before it's deemed automatically approved? If you don't object to it or pay it within a certain amount of time, are you on the hook for attorney's fees or interest or something like that? These prompt payment statutes, there are custom edits that a well-advised contractor is going to want to consider in their owner contractor agreement to address that stuff. Same thing with the Mechanics Lien Act. Many states are going to prescribe what kind of sworn statements and lien waivers and other documents are going to be required, not just by you, the general contractor, but by your subcontractors. And addressing these things in the contract and getting from the owner, what form of documents are they looking for before you sign the contract? It's a good thing, whether I represent the owner or the contractor, I'll generally have sample pay apps, sworn statements, lien waivers, so I can understand what the owner and its title insurer and its escrow agent and its lender is going to want from you, the general contractor, to make sure that you don't sign a document, do work, and then you go submit your first pay app and you realize that they have a different idea of the sort of things that you're supposed to get your hands on. Maybe it would be current mechanics lien waivers and your subcontractors wouldn't be willing to provide you those. So, I'm just scratching the surface here. There are so many issues that are state law specific. Retainage, like are there limitations on retainage? How much are they allowed to keep for how long? When do they need to release it? Indemnification. It might be the case that the owner wants you to violate state law and agree to an indemnification clause that is broader than the law will allow. These are the kind of things that when I'm representing you, the general contractor, I'm gonna get my head around, and I'm gonna propose these client and project specific edits, these state law specific edits, because I'm interested in having a great contract, not for its own sake, but because it's the key to having a great project. I'm all about good work for a fair price, projects delivered on time and on budget. I'm all about not having disputes, because what do you want to do? Do you want to sit in depositions and deal with mechanics liens and deal with litigation? No, of course not. You want to have happy clients and happy subcontractors, and you want to get paid, and you want to add to your portfolio and add to your capabilities and roll on to your next projects and have fun doing it. So the reason why we want the right project delivery method, the right contract terms, the right contract forms, is because that is the way that people like me can help people like you, general contractors, achieve those win-win outcomes that allow you to have fun building. With all that in mind, I want to take a little bit of time and I want to run through very quickly the 16 different articles of the A102-2017 owner-contractor GMP agreement. Obviously, I'm just scratching the surface here. We are going to be talking about 1% of the stuff that you might need to think about. But when I run through these documents, it's interesting to look at the standard language, but it's also notable to appreciate that there's quite a lot of concepts that are not addressed in the off-the-shelf standard form agreements. So I'm going to take a quick run through these 16 articles and just give you very high-level thoughts about some issues that I might like to address on behalf of my general contractor agreements with custom language in order to protect them and lead to those win-win outcomes. Article 1 of the A102-2017 deals with the contract documents. Obviously, the capital C, capital D contract documents are code for, what documents spell out your obligations as the contractor. They spell out, what is the capital W work of the contract, and essentially what you owe the owner in exchange for the payment that you're going to receive. It's pretty important to make sure that your assumptions and your clarifications and your exclusions, the couple of pages that you package up and you send over the transom to the owner with your proposed guaranteed maximum price are factored in here. Sometimes an owner is not going to want to include your assumptions, clarifications, and exclusions as a contract document. There's middle ground here where you can sort of work with that and work around it to make sure that when it comes to your entitlement to a change order, that you're going to be able to say, yeah, I know that that's what the drawings say, but look at my, exclusion here in this division. And so whether the owner is going to allow your document to become a contract document or not we could still achieve clarity by making some custom edits in Article 1 around, what do your assumptions, clarifications, and exclusions mean, so you don't wind up in a situation where you owe the owner more work than you intend to perform, and you're able to capture all of the fee that you're entitled to, either by way of, it being just part of the original work or by change order, and, winding up in an end of project position where you don't have somebody coming to you and wagging their finger and saying that, you didn't do some work that you were supposed to do. So, thinking about what are the contract documents, what's the pecking order of them, which govern in what order, what's the relationship between the GMP and your assumptions, clarifications, and exclusions, and the design team's drawings and specifications. Very important as a well-advised contractor to get some custom language kind of in to Article 1 or in other places in the document to address these important concepts around what is a contract document and what is not, and what happens if they conflict, and so forth. Article 2 of the A102 contract document talks about the work of the contract, and again, work, capital W, it's a defined term. The A102 assumes that, the general contractor's essential obligation is to execute the capital W work of the contract. You have to make sure that the work of the contract is being defined properly, through the contract documents, but also you have to validate that assumption. You got to be careful, because if the architect or the interior designer or the owner is going to procure some of their own furnishings, fixture, equipment, materials, that may require there to be some nuance around the fact that there's work of the project that's different than the work that you as the contractor owe them. Maybe your work involves installing some of this stuff, but not buying it. And that kind of gets to what happens if it gets damaged or lost in transit? What happens if it gets stolen, at an offsite warehouse? It's different than if you buy it and install it. So, we have to validate the assumption that the entirety of the project, is actually work, capital W, that you are going to perform, because it might be the case that there are separate contractors. There may be maybe fire protection, contractors are going to be hired directly by the owner. And so some of the work of the project might not be your work. And so we got to think very carefully about what is the work of the contract, and to draw the distinction between that and any other work that the owner may expect from other parties, that is the work of the project. So you don't tumble sideways, into an Article 2 of the A102 document that commits you to do more work than you intend to do for your fee, which is less likely to come up in the execution of the project and more likely to come up in a claim later when somebody feels like something didn't get attended to properly. Article 3 of the A102 talks about the relationship of the parties, and it has in it the 5 most dangerous words in construction contracts, and they are relationship of trust and confidence. There is really good reason why it's fair for an owner to expect those words to be contained inside your contract when they are paying you on a cost reimbursement method of project delivery. I think all things being equal, it's fair for those words to be in there, but they have a deep and important meaning that I address in other videos on my website. I think one actually may even be called the 5 most dangerous words in construction contracts. So you got to know, what is it to you as a general contractor to enter into a relationship of trust and confidence with the owner. There's also room to insert the word reasonable several times into Article 3 of the A102 if I'm representing a contractor. Article 4 deals with the date of commencement and the date of substantial completion. If you're a well-advised contractor, you got to kind of stop and think about, does the commencement of the work, meaning when does the sand start to run out of the hourglass for you to complete the project? When does the hourglass get turned over and the sand starts to run? Does that commencement require anything? Does it require an initial payment from the owner? Does it require the owner to have a building permit in hand? Does it require them to prove that they've got certain insurance, builder's risk insurance, property insurance? This is just the tip of the iceberg. There's a number of ways where a well-advised contractor may want to edit Article 4 to qualify what needs to happen on the owner side before that date of commencement starts to run. And there's also room to address in Article 4 or in other places within the contract documents, including, as I mentioned, Article 8 of the A201 General Conditions, which talks about time. What happens in the event of delays? When are you entitled to an extension of time? Where is it appropriate to have force majeure language? Where is it appropriate to have language that addresses owner delay? What happens in the event that there's delay? Do you just get more time? Do you just get more money? There's circumstances where it'd be appropriate for you to get neither, or one, or both. And whether it is in Article 4 here, or in Article 8 of the A201 General Conditions, or somewhere else in the contract, these issues of delays and extensions of time are very important to address. And it's worth thinking about those issues when you customize Article 4 of the A102, which talks about the date of commencement and the date of substantial completion. Article 5 of the A102-2017 talks about the all-important contract sum. And I like to make the joke that, contractors only edit contracts for sentences that have dollar signs in them, which is, sometimes a little true because contractors are often most concerned about matters of their compensation. Of course, it's more joke than not. A well-advised contractor is going to be thinking about 1,000 things beyond just their compensation. But Article 5 of the A102 is a particularly important article because it talks about the contract sum. And the contract sum, of course, is what you're going to be paid. It is the cost of the work plus a fee, which, a cost of work is often going to include your general conditions. It's going to include the sorts of things that are described in Article 7 of the A102, which are those costs that you will incur for which you will be reimbursed. So you're going to want to pay a ton of attention to Article 5. You're going to want to put in some custom edits as a well-advised general contractor. This is a great place for you to address the concept of shared savings. Is it a 50-50 split? Is it a 60-40 split? Is it a different split? Exactly what is savings? When are savings calculated? Is it right after buyout of your subcontracts? Is it at the end of the project? There's a ton of stuff to think about customizing in Article 5 if you're a well-advised GC. Matters of allowances. A well-advised contractor is going to state clearly that, allowances are going to be reimbursed for their actual cost plus their fee. And if they're more than the, amount that is stated in, the baseline agreement, they're entitled to more money by change order. I think that is a concept that we all know what an allowance is in the industry, but I don't know that this is as well addressed in the AIA contract documents, including the A102-2017, as it could be. Are you going to have liquidated damages on your project? If so, Article 5 is a place that it's customarily addressed. I know that most contractors have a knee-jerk reaction about hating liquidated damages, and I can certainly understand that. I would just mention that liquidated damages are, in a sense, actually a form of limitation of liability for contractors, which is not to suggest that you want them in your agreement. It's just to say that this is a double-edged sword. And whether or not you really want liquidated damages or whether you really don't want liquidated damages, it's client-specific and project-specific. And these are all things that you and your construction attorney can hash out. When we talk about the contract sum, you're going to want to address your general conditions or your general requirements, right? We all know that these are often time-based costs. A month of trailer, a month of porta potty, a month of temporary heat, a month of fencing. It's not always the case that general conditions and general requirements are time-based, but they often are. And if they are in your instance, you're going to want to address the general conditions or the general requirements as being part of the contract sum. You're going to want to spell out what they are, and you may want to think about being clear about under what circumstances would you be entitled to more money if there is an extended duration of the project. And certainly in an era where we talk about pandemics, in an era where we talk about tariffs, there's room to consider asking the owner to include language that would give you an equitable adjustment of your guaranteed maximum price. If there are certain industry-wide events or industry-wide escalations, which are beyond your reasonable anticipation and control. As I sit here recording this right now in February of 2025, I have no idea what tariffs are going to be in place, tomorrow, Monday morning. And so this could be particularly important to contractors. I know that this is top of mind for you. And I would say that there's a lot of reasons why an owner is going to push back on this kind of an equitable adjustment of the guaranteed maximum price. But there is a secret sauce that experienced construction lawyers have, certain ways to put words together so that the owner is more likely to accept this sort of thing. I've actually had quite a lot of success getting language into contracts to benefit my contractor clients, to make sure that they don't get hurt by industry-wide, escalations or things that are beyond their control. And so this is a good place to think about some of that custom language. Article 5 of the A102-2017, which talks about the contract sum. Moving on to Article 6, it talks about changes in the work. Obviously, we're not talking about change orders. We're talking about construction change directives. A well-advised contractor is going to want to think about some custom language in Article 6 to talk about how your fee is calculated. Is it different in change orders than it is in construction change directives? Is it different in the base agreement than it is in those instances of change? What about fee stacking? If you've got multiple tiers of subcontractors and suppliers, are you allowed to stack their fees? Are there any limitations on that? You're going to want to be thinking about these things when you're negotiating Article 6 with your owner client, if you're using an A201-2017. As I mentioned earlier, Article 7 is arguably the most important article of the A102-2017 because it is entitled Costs to be Reimbursed. And this is where the contract goes in a great detail about the capital C, capital W cost of work, which is code word for the kind of money you're going to get reimbursed for. I can't tell you how important it is for you to read the heck out of Article 7, Costs to be Reimbursed, and read the heck out of Article 8, Costs to not be reimbursed, because these are literally, code words for what you're going to get paid, and there's definitely room for a lot of nuanced edits in Article 7, but, a well-advised contractor might consider kind of an overriding statement to kind of, lay over top of all of Article 7. It might be something like, that you'll be reimbursed for all costs necessarily incurred by the contractor in the proper performance of the work, unless specifically provided in the agreement. That's just one of a lot of different ways that we could describe key concepts that could be more clearly stated in Article 7 in order to give contractors a lot of clarity around some of these important issues. I heavily edit Article 7. We are talking about the tip of the iceberg, so I don't want you to think what I just said is comprehensive. There are a lot of things to be concerned of. I think related party transactions, in other words, like if you have, as the GC, have some relationship with a supplier or subcontractor, whether maybe you're a relative of the owner of the sub or supplier, or maybe they're a subsidiary or some sort of a related party with you, or if there's some sort of a quantity discount you're going to get, you got to watch out for some of that related party language transactions. But read the heck out of Article 7. It talks about the costs that you're going to be reimbursed, and make sure that you understand everything. Make sure you put your custom edits in. And if you don't know what they should be, talk to a construction attorney. They can help you out. Of course, Article 8, costs not to be reimbursed. Also very important for you to read very, very carefully. And you may want to think about dozens of edits in here, but maybe some of those overriding qualifying statements, maybe something like, that the cost of the work, capital C, capital W, is not going to include the items that are listed below in Article 8 unless the parties otherwise agree, because maybe there's something in your qualifications, your clarifications and exclusions that are going to be at odds with the description of what's the reimbursements are in Article 7 and Article 8. And so we got to make sure here that we have clarity so that you get paid the dollars that you're expecting to get paid. Article 9 specifically deals with discounts, rebates, and refunds. All that I will say to you is that if you are a contractor that is being reimbursed by an owner in a cost reimbursement method, subject to a guaranteed maximum price, you better be really careful to not take discounts, rebates, and refunds and assume that they're going to inure to your benefit and pocket them while charging the owner full price, unless you have some clarity around who's entitled to those discounts, rebates, and refunds. And there's definitely ways that we can kind of qualify this standard language in Article 9 to make sure that it's clear that the owner shouldn't expect to get, those mass purchasing discounts, because it has nothing to do with their project. It has to do with the volume of work that you're doing on a lot of projects. But there's room for sure in Article 9 to qualify the standard AIA language to make sure you don't get hurt as the general contractor. Article 10 of A102-2017 talks about subcontracts and other agreements. A well-advised real estate developer or project owner is going to want to exercise a lot of control here. They're going to have an interest in including information about how many bids per trade are you supposed to get, and open book bidding, and subs not being allowed to just be T&M without a fixed fee, or at least some kind of unit price constraints, or not to exceeds, and owners who are going to give you a cost reimbursement agreement, if they know what they're doing, are going to want to have a lot to say about subcontractor selection. And so I think that you, as a well-advised general contractor, are going to want to have your eyes wide open here. And you're going to want to try to counter some of the owner's custom edits with your own, or if they don't push for them, happy day for you. There's definitely some custom language that we've not covered that you're going to want to include in Article 10. And I think that, just to give you one of 100 potential examples, owners are going to want you to pay your subcontractors promptly, but I think that it's important to clarify that you're allowed to withhold payment from the subcontractors to protect you and the project and the owner from poor work. And so, these are just some concepts, 1 in 100, 1 in 1,000, that are not addressed in the standard A102-2017, not because it's not a bad document, but because it's already quite long. And if the AIA were to endeavor to address every single issue that could ever come up on a project, it'd be 100 pages long instead of 20 pages long, and then everybody would be annoyed at the length of the document. So I'm not suggesting it's not a good agreement. I'm just saying, as I stated, it's a starting point. You don't just take one of these contracts, fill in the blanks, and assume you got a complete and a good contract. Article 11 of the A102-2017 talks about accounting records. Owners have an understandable interest in making sure that if you tell them that you've incurred certain costs in executing their project and you wish to be paid for them, that they have the right to validate that. So it's a standard industry assumption that they're going to have some access to your accounting records. They're going to have some audit rights. They're going to have the ability to bring in auditors to your office. And, the extent of those rights are where you can really include a bunch of nuance to try to protect yourself. Looking at documents is the same thing as taking them out of your office. There are certain kinds of job cost type documents that may be outside the bounds of what would be within an owner's right to take a look at and copy. These things are all points of negotiation. There isn't really a right or a wrong, other than to say that if you're a well-advised contractor, you're going to want to have your eyes open, and you're going to want to think really hard about Article 11, accounting records, and you're going to want to include some custom edits. Certainly, at a minimum, I think that there's room to include the words reasonable or reasonably several times in Article 11, if you're a well-advised general contractor. Article 12 talks about payments. Here's the joke that contractors only edit sentences that have dollar signs in them. Ha, ha, ha. That's not entirely true. But Article 12 payments in the A102-2017 contains some provisions that required some of the most important edits that I put in for my well-advised general contractor clients. There may be room to create some kind of a procedure or ways to qualify the owner's right or timing or way that they dispute your invoices so that you don't get surprised at the end of the project and have people raising concerns about invoices, that were paid long ago. You're going to want to address retainage here. If it's going to be withheld by the owner, on what, when is it going to be released? Are there things that are not subject to retainage? What about your subcontractors, like, that dig the foundation, pour the concrete? They're going to be done years before substantial completion. Like, here's where you're going to want to have some custom edits. You're going to want to have some custom edits about the logistics of the payment application process. Do you need lender approval? Do you need title insurer approval? Do you need escrow agent approval? What documents are going to be requested of you? Are they current lien waivers? Are they trailing lien waivers? Here is where you're not going to want to have a lot of ambiguity if you want to get paid. Are you going to get paid directly? To what extent does the owner or some of these other parties have the right to pay subcontractors? How are we treating contingency? To what extent do you have the right to use contingency dollars? Like, are you allowed to reallocate contingency from one line on your schedule of values to another? Do you need permission from the owner? These are all things that are really important to think about in Article 12 payments. And again, we're scratching the surface. I have covered just a small sampling of the things that you should consider, so don't think this is comprehensive. I'll say in Article 13 for you the same thing that I'd say for owners. Article 13 of the A102 talks about dispute resolution. And as much as I like to think about good contracts as being like the project manual, like the ingredients for how you bake the cake and how something you should have at hand all the time, it's sad to say that too often contracts are signed and shoved in a drawer and not read unless there's a disagreement. And that's why I sometimes hear people joke that they shouldn't call contracts agreements, they should call them disagreements, because people only really get worked up about them after they're signed if there's some kind of unhappiness. But Article 13 of the A102 is the dispute resolution section, and this is where I like to put some of the most important edits that I could stick in there to make sure that you don't get stuck working but not paid. To make sure that you don't wind up in a situation where you get put over the barrel on a change order, and you wind up having to do the work and maybe without having agreement about, what you're going to get paid. There's a whole bunch of alternative dispute resolution provisions, creative provisions that I would stick in here to benefit not just you as the contractor, but the owner also, about breaking through impasse in the middle of the project so that we don't wind up in a situation where the train jumps the tracks and the project doesn't get completed and you wind up in litigation, or almost as bad as you wind up in litigation at the end of the project. Like, I come from the school of nip it in the bud. I help my contractors and my owner clients deal with disputes in real time so that we can have that early resolution of these discussions before they bloom into disputes. In Article 13 A1 of the A102, which addresses dispute resolution, very important, lots of room for custom edits here. Article 14 of the A102 talks about termination or suspension. And there's a lot to think about here if you're a contractor. There's a lot of room for custom edits, and it's not just what you're entitled to be paid, it's what you're entitled to be paid if there's a suspension. What if the suspension is temporary? What if it's permanent? What if it's very lengthy? What if there's some material thing that happens in the middle of suspension? Like, do you have the right to terminate? Can you terminate for convenience? Can you only terminate for cause? Under what circumstances can the owner terminate? Under what circumstances can they only terminate for cause? Are you just entitled to be paid for work that you've executed? Do you have any right for profit or overhead on work that you didn't execute because you set your team's capability aside and you didn't take on other projects, and now they're going to twiddle their thumbs because the project is terminated or suspended until you can backfill them with more work and replace that fee? There's a lot of room for a well-advised contractor to consider custom edits in Article 14 of the A102 around rights and obligations pertaining to termination or suspension. Article 15, miscellaneous provisions. This is where I like to include what I call my secret sauce. There's a whole bunch of stuff, so many provisions that we could stick in here, and I don't stick them in every one of my agreements. It's client specific, project specific, state law specific, and so you shouldn't take what I'm about to say as anything other than a small sampling of issues to consider. But You know, who has to protect adjacent landowners? What happens if we discover hazardous materials? You know, there's certain critical insurance concepts that should probably be addressed in Article 15 miscellaneous provisions. You know, to what extent are you obligated to review the contract documents and, you know, the issue for construction documents? And to what extent are you obligated to act, you know, in capacity as a design professional if, say, there's design build subcontractors, you know, design build MEPFP, a design build curtain wall under you, you know, or, you know, is it a case where it's a fully engineered and architectural project where you're not doing any work as a design professional? I mean, it's good to get clarity on whether you have any obligation to serve in capacity as a design professional, and, you know, to get clarity around your review of the documents prepared by architects and engineers is not the same level of review that you would necessarily be undertaking if you were a design professional, if there's language that says that you have to agree to review them and to sign off on their adequacy and completeness before you sign the contract. There's key terms that need to be addressed about warranties, about their type, about their duration. There's a difference between your warranty and your subcontractor's warranty and your supplier's warranties. Are there any limitations on any of those things? And so this is a place, miscellaneous provisions, Article 15 of the A102, where you can think about some of those things. You know, you got to be careful to comply with state law if you're going to try to disclaim certain warranties, particularly certain implied warranties. There's also critical terms that you need to think about indemnification. You know, is your indemnification going to include a defense obligation? You know, is it a one-way defense and indemnity obligation, or does it both ways? Does the owner have some obligation to defend and indemnify you? Another issue, do you have a right to cure if the owner says that you've done something wrong? What are the specifics? Are you entitled as a contractor to any limitations of liability? Are any kinds of damages going to be waived, like consequential damages? You know, are there any third-party beneficiaries beyond your owner client that can sue you on your contract as a third-party beneficiary? This is a place in Article 15 miscellaneous provisions of the A102 to address those things. What happens in a rehab job? What happens if there's hidden conditions? What kind of credit and publicity are you entitled to? Can you post images on your website? Can you put them on your social media? Can you put a sign out front? You know, how can the owner accept the contract? You know, like, do they have to sign it, or is it, you know, enough for them to get the contract and then start paying you to do the work? You know, there's a ton of nuance here. And again, I am scratching the surface. So please, please, please do not hear this as a comprehensive list of the stuff that a well-advised contractor is going to want to consider when they think about custom edits to Article 15 miscellaneous provisions of the A102 GMP agreement. One of the things that I think is really important to consider is Article 16, enumeration of the contract documents. This kind of goes hand in glove with Article 1, which talks about the contract documents. I can't overstate the importance of making sure that it's clear what the contract documents include, what they do not include, what the relationship is between your assumptions, clarifications, and exclusions, and your GMP, and any allowances or alternates you may have, and, you know, the drawings and specification issued by the design team. There's room for custom language in Article 16, enumeration of the contract documents, to make sure that you don't wind up agreeing to build something beyond what you priced. And one of the things that I like to do is I like to put right above where the owner signs at the bottom of the A102-2017 certain mandated disclosures that you may have to make. Some of these are state law mandated disclosures, some are federal law mandated disclosures, but, you know, I like to add a custom Article 17 to protect my contractor clients. I like to put it right above the signature block, so there's no room for the owner to say that they didn't see or understand that those disclosures were made to them. And we've really, even though this is a long video, we've really just scratched the surface. The bottom line is that I think the A102-2017 standard form of agreement between owner and contractor, where the basis of payment to you, the contractor, is the cost of work, capital C, capital W, defined term, laid out in Article 7, plus your fee, which is typically percent based, with the GMP. It's a great contract. I love the A102-2017. I don't think it's overly unfair or fair for any particular party. I use it all the time. I do think that no matter whether you're a well-advised owner or a well-advised contractor, you're going to customize the heck out of this contract document, just like any other contract document, to make sure it's a complete thought. That's the only way that we get good work for a fair price, projects delivered on time and on budget with no disputes, is if everybody has their eyes open at the beginning of the project with custom terms, so that it fits like a glove. Even though I'm, all things being equal, probably going to prefer an A101-2017, that fixed contract sum agreement that I talked about, and I would encourage you as the contractor to check out some of my other videos on the A101-2017 and others about the difference between fixed contract sum and cost reimbursement contracts. Even though all things being equal, I think the A101-2017 is probably a little bit less dispute prone. As I mentioned, I love the A102-2017 cost reimbursement up to GMP agreement. I use it every day. Probably going to use it every day for the rest of my career. There's a lot of advantages for contractors that are able to seek cost savings and other advantages that I've not covered in this video. So all things being equal, the A101 is simpler and less dispute prone, but if there's a good reason for you to use an A102-2017, I think it's a fantastic document. And I would encourage you to use it on your projects where it makes sense for you to do so, given the nature of the project and your client, and your ability to execute on the promises that the A102-2017 makes on behalf of the contractor.